Morning, Las Vegas. This is Tina Drago with Healthy Las Vegas. Today I have in the studio Martina Jaccarino. She is a lawyer in town, and we're going to talk about the health of law and how your health can actually affect your job and your stress levels and other areas of your life that you may not thought of. And there are resources for you. Good morning, Martina. How are you?
I'm doing great today. How are you, Tina?
Doing wonderful. So talk to me about the healthy side of law. So you have people that come to you with health issues?
Well, a lot of people who have had significant health issues will understand that that impacts all areas of your life. And one of the most significant impacts can be on your income and your employment. So what I do with people that come that have health issues, I help people understand how to interact with their employer about that.
Okay, so I have an employee, and this employee has a short term. Let's start with a short term. They got into a car accident, and they're going to need maybe chiropractic time off, or they're going to need time off for going for doctor's visits and stuff like that. It's my obligation as an employer to give it to them.
It's not an absolute obligation, but it is your obligation as an employer to interact with the employee to figure out how much you can accommodate that without it having too big of an impact on your business.
Okay, so depending on your business. I mean, if you're maybe a salesperson that can take time off between sales, that might be easier than maybe a secretary or somebody that actually has to be at the desk the entire time.
Exactly.
Okay.
A lot of the clients that I get have been terminated from their jobs or have had their pay reduced because they had what the employer deemed to be poor performance. But if you are struggling at your job because of a health issue, it is important for you to take it on yourself to interact with your employer and tell them why maybe you're missing a little bit of time at work, or maybe you're not being as productive as you used to be. Because once you explain that to them, they do have an obligation to seriously try to accommodate you.
And most bosses are human. They get it. The last thing a boss or a supervisor wants to deal with or grapple with is trying to figure out what's going on. So we really just should be upfront with people and be honest, even if it's embarrassing, even if it's personal. They have to actually have that conversation, right?
Exactly. Right.
Okay.
Both sides have some obligation of communication. In most instances, the employer is aware that the employee is having some kind of health issue. It's very rare that someone comes and has not given their employer any kind of heads up. Then the issue becomes, how was their performance before they had problems at work?
Right.
And then also, was the accommodation that they needed reasonable? Would it have a huge financial impact on the business? If it would have a big financial impact, then maybe the employer was right to say that they can't accommodate. But in most instances, if the employer just terminates the person without trying to figure out a way to accommodate them, now our society has decided, we have Supreme Court cases and we have local cases, we want people to be able to work.
Right.
So we should be trying to accommodate people so that they can work. And if employers don't do that, then that's when they get into trouble.
Do you find that it's more of the smaller businesses, not the mid-size or big corporate businesses, but it's the smaller ones that struggle with this hurdle?
Yes. In fact, probably the most valuable service I provide is risk assessment and loss prevention to employers. I've done 16 trials. You and I have talked about that before. It's really a valuable experience. I know what policies and procedures are going to lead to possible litigation risks. And I come to people's businesses, especially small businesses, I can give them advice that can save them thousands of dollars in attorney's fees and a lot of stress.
I know that I had an issue with people wanting to volunteer. I run a nonprofit medical clinic, and people would say, well, I'll volunteer for you. Well, that's a slippery slope because according to the EEOC, there's only 3 categories in the state of Nevada that allow for volunteer time, and that's police, fire, and doctors. So if they're an administrative person, they're not allowed to volunteer. They can come back and say, well, I put in 20 hours and I expected to be paid, and you're saying no, you volunteered, and you're stuck. So I got slapped on the hands with that. That was a tough pill to swallow, starting out as a small business trying to do good in the community, and that sting. I wish I would have known about ahead of time. I would have put preventative measures in place.
Exactly. That's a perfect example. And a lot of small business owners are under the impression that most employment discrimination laws do not apply to small business owners. That's not true.
That's absolutely not true.
It is absolutely not true. I don't know where they get this idea. I think maybe it comes from the fact that, as a general matter, employment cases, even if someone has been discriminated against, they're not set up to make the terminated employee rich. The former employee is only going to be made whole. If you have a small business, compared to what a big business is looking at as far as liability, your exposure to damages is not that big. But when you're a small business, if you have to pay someone $20,000, that has a big impact on you for your business.
Huge. And by the way, small businesses out there, there's penalties also that go along with this. So like for my volunteer people, I actually got penalized more than I owed them in hourly wages because I didn't pay them within a 30-day period. And that was impactful. That was also another eye-opener.
Right.
Right.
Right. And I think a lot of businesses, small and up to medium, don't cover what's employment practices insurance. I mean, bigger companies, huge companies set aside money for this exact issue, and they put a lot of time into loss prevention because they can be hit with millions of dollars. Yeah. But with smaller businesses, sometimes you're looking at the cost benefit. You don't investigate every type of insurance available. There is insurance available. And even if you don't think that your exposure is very big, the cost of defending an employment case is very significant. So to at least have that insured is a good idea.
And that's funny because I had no idea, or I would have probably looked into it. Most of us small business owners out there in Las Vegas land are usually the HR. We're usually the accounting. We're the owner. We're the executive. Sometimes we're the sales. So there's a lot of hats. And if it means having that added insurance out there as kind of a peace of mind buffer, I think that's worth looking into.
Yes, and it's not expensive. It's not expensive, and at least if you have your cost of defense, it gives you a little bit of peace of mind.
Right.
Because as you mentioned, those penalties and fees can add up to the state, but attorney fees are a huge drain. And even if a case settles really early on or has problems that maybe it wouldn't win at trial, most of the time the plaintiff's attorney gets their fees paid as well. And they get those fees paid by the defendant.
Very true. I had I always go back to my worst case scenarios. I had a lawsuit from an employee who called in sick to work and then didn't come back in for 4 weeks. And I terminated her. She abandoned her job. And she went to, and this wasn't in Nevada, this was actually in Wisconsin. She went to the EEOC and said that I fired her because I didn't want to pay the medical bills for her cancer. Now, I was not aware of her cancer, and I was not aware that she had any health issues. I thought she was staying home for a cold or something like that, calling out of work sick. It didn't stop her from appealing 5 times, which was her right, over the year, incurring lots of legal fees on behalf of the business, to find out in the end she didn't even have cancer. So I was like, it was my worst case scenario of an employee just wanting to screw around and was looking for stuff. So, if I would have known a lot of what I knew up front, because I actually spent, I was like $5,000 on lawyer fees, just appealing, just writing the appeals of it. So it does add up, and, it is expensive. And who wants that?
Right.
When you're trying to just run a day-to-day business.
Right. And OSHA and the EEOC, I mean, they're wonderful organizations, and we need those agencies. But the employer has to remember that they are the entire reason that those departments of the government exist is to protect the employee. So if you have the EEOC or OSHA coming to your small business, you are on the defensive. I mean, they're not coming with a clean slate. They're coming with the assumption, really, that
you did wrong.
Right, that something irregular has happened. And it's not a defense to say that you didn't know.
You also must respond.
Right.
You can't say this is frivolous and walk away. You have to, as the employer, respond.
Right.
It kind of stinks.
Yes, it is. It's a really tough area. Most attorneys only stay on one side of this issue. But I've been an attorney for 20 years, and I have a
You look great
reputation.
for your age.
For honesty. I have a great reputation for honesty, and apparently I look great for my age. That's good too. But and I work with a lot of big companies who are doing it right. You know, they're doing everything they can to try to make sure that all of their managers down to the lowest level manager is doing it right. But that doesn't mean that there's never a mistake made, because even if the people at the top of the business want to do it right and have all the right policies in place, the whole point of having lower level managers is that you're not watching them 24 hours a day or the 8 hours a day that they're at work. So things happen, but when you put the right policies and procedures in place and show that you're trying to do the right thing, that can actually save you a lot of grief and a lot of money in damages if the case ultimately goes through litigation, because you can show that you had a company culture that encouraged tolerance, that let everyone know that they're supposed to be trying to accommodate, that let the employees know about their rights. And so as far as small business owners go, the fact sometimes that they don't obviously all have human resources departments causes them to not do things like invest in having a policies and procedures manual.
Right.
That can give them peace of mind, that can save them huge amounts of costs over time. Because I think small businesses are in some ways exposed to employment discrimination losses more than bigger businesses, because they're hiring people in a different way. And
we hire people emotionally. Very few small businesses make you do like personality tests or
and background
checks or things like that. You know, we hire on referrals, and we hire on can they get the job done, and we have a whole different perspective.
Right. I have a client who's dealing with a pattern plaintiff. This person has gone to a few different offices, small businesses, and she has exhausted every single type of employment case that you can make at more than one office.
Has she said she had cancer but didn't? Because she sounds like the lady I had.
No, but she did literally stage a fall after she knew that she was going to be terminated, and then claim that she got terminated because she had the fall.
Right.
Things like that. You know, it's a never-ending drain. It's great business for me, but my poor client has gone through a lot of stress. And if he had someone do a routine background check, which really is not expensive,
he would have saw the pattern.
Right, exactly. He would have seen the pattern.
I usually get people that want to be fired so they can go on unemployment and take the summer off and don't have to get a babysitter for their kids. I honestly, that seems to be where my easy spot is. So I look at that. Yeah, you start seeing their performance wind down, or they just refuse to work. Yeah. You're constantly telling them go back to work, and they're just looking to be fired.
Oh, wow, that's terrible. That's a bad experience right there too, because it's a constant drain, and it's hiring and firing takes time.
It does, and it is a constant drain. I've learned to put them on 3 days a week, 2 hours each day.
Really?
Yeah, they'll quit.
Oh, wow.
When I see the play, then I get upset, because there's so many people out there that truly need unemployment, that truly can't get another job, that truly have this, and they're not playing the system. And it should be there for people, not people that actually have a job and just refuse to work.
Exactly. That's so true. And it, frivolous lawsuits cause a lot of drain on the system. And they also make it harder for people who have claims of merit to get the representation they need and get the money that they deserve to get. And that is why, I usually take maybe 2 plaintiff cases a year, because my background is insurance defense. I am a commercial litigator. I represent companies. I represent health clinics and doctors most of the time.
Yay!
But, yes, but
and just for clarity's sake, Martina is on my board, so don't mess with me.
That is true. That is true. That is true. But I have had a couple people come to me and they've been mistreated. I mean, they have been employees at businesses where the culture is blind, so that if someone is a minority or has a disability, that there isn't a manager who will give them a fair shake. They aren't able to see that person's performance anymore. And they need to be educated. And I'm a perfect person to educate them, And that's why the system is the way it is, that, these people do deserve to be made whole. I mean,
yes, I agree with that. We love diversity, and we're really colorblind and performance blind. My big thing is do your job and have your education and continuing education going on. So I don't care if you're from Mars and you're purple and you got 3 ears. As long as you do your job, I am excited for you.
Yeah, exactly. No, and that's the way it should be. And I think that's the way most employers are. I think in this day and age, I truly believe that there are few employers who are guilty of outright knowing discrimination.
Right.
But that doesn't mean that they're giving people a fair shake. One of the things that's developed a lot, I think that employers are still trying to catch up with, is a huge shift in the protections available to people because of medical issues.
Right.
Because medical issues, 15 years ago, your medical issue wasn't even a private matter. And now...
You're right. HIPAA's a new thing. And if you were pregnant and took off time from work, you could lose your job.
Right. And once they made your medical issues private, that created a situation where you could have an employee who claims that she had cancer, and it's not immediately on its face impossible.
Right.
Because you actually, as the employer, cannot ask the employee about their health. They will ultimately always, if they're bringing a claim against you, they're going to claim that they told you. And it's to establish, to meet that burden that you didn't know.
Can employers ask the employee when they have this conversation with them to put things in writing?
They should. I mean, they should ask people to put things in writing. And if they agree to accommodate someone, they need to put the accommodation specifically in writing. The employer needs to go to physical therapy 3 times a week. And when you meet with them, they say they're only going to have to leave an hour early or come in an hour late. But then what ends up happening is they're gone for physical therapy for 3 half days of the week.
Right.
That's a different accommodation, and it can make a huge difference for a small business. So you need to have people put this in writing. But the standard for whether or not someone has a disability that has to be accommodated is whether or not they have a health issue that has a significant impact on their daily activities.
I had a doctor who I interviewed and was going to hire last year who didn't tell me that he needed a anxiety service dog to be with him at all times. That was huge.
Wow.
It just so happened that I said to him one day, well, it was like our 3rd interview, right? And I was getting ready. He was gung-ho. And I said, why is your dog with you all the time? And he goes, well, it's my service dog. He'll have to be here, and you'll have to make accommodations for me in the clinic. And I'm sitting there going, well, wasn't that a surprise? Because that wasn't told to me up front, which he didn't have to tell me.
Right. And can
front.
you have a dog in a medical clinic? I don't even know if that's... It doesn't seem like... It makes me think of not being quite as clean, although...
Well, that was it. And he said the dog, and I said, well, how do you go into an exam room and see patients with it? And he goes, oh, no. The dog just stays under my desk. And when I come back, then he goes, so I'm going to need my own office. So I don't know if you guys know how most medical clinics work, but like the providers have, if they're lucky, a room
right.
that has multiple computers on it, because their job is to be in the exam room. It's not really to have a private office. So, so that wasn't going to accommodate, and he'd have to be in there with other people. And, it was one convolution after another. I feel like I really dodged a bullet on this one, because then I picked up the phone and I made some calls to his previous employers, specifically asking, did you have to make special accommodations for his service dog? And they were like, yes. And I said, and why? And they said, well, he has PTSD, or because he was a military provider. And I said, okay, I understand that. But in those situations for our clinic, that would not have been a good situation. If he was in a private practice, that would have probably been a much easier situation for him to excel in.
Well, you wouldn't be able to accommodate a need for a private office in your facility because your clinic
We don't
is
have
not
private.
exactly. That's what right.
We have no private. My office isn't private.
Right. Exactly. That's I was thinking. That's your focus is so on patient care.
Yes.
Every square foot of that place is taken up with
Exam
equipment
rooms
to serve the patients
Yeah.
or exam rooms, so that would not have worked. And it's a good example of an accommodation that might be very easy for some businesses to accommodate,
Right.
and just not practical for other businesses to accommodate.
Exactly.
And hopefully he understood that, although I'm surprised he came for a third interview because he would have seen your facility, and it's not laid out to have a private office. That's interesting.
I think he was looking at my office, which, by the way, is the CEO office, the accounting office, the HR office, and people come and go constantly in it. I think he was looking that would be where he'd camp out.
Yeah, but
Yeah.
you have
So-
to have one place that the CEO or the director can interact with employees, because
Right.
going back to the privacy that employees are allowed to have, if an employee talks to their supervisor about their medical issue and anyone else in the office ever claims to have knowledge of that issue, even if the employee was good friends with the person who knows about the medical
Right.
issue, that employee can come back later and say, I never told anyone except for my boss. And then my boss went around the office and told everyone. Obviously, HIV is the case study. I mean, that's where HIV is the
Yes.
disease that brought about, really brought about HIPAA and confidentiality.
Well, there was such a panic and a scare that was surrounding it that really, as we found out now, is not actual.
Right.
But yeah, that paranoia
Right.
really affected a lot of people, and it's a shame.
Right. There were landmark cases and punitive damages type cases where employers were kind of openly discriminating against AIDS patients. So but what's happened, and what happens a lot in the law, you have an issue that makes a lot of sense, and you have case law that comes out that makes a lot of sense. But then, we lawyers get a hold of that case law.
Oh, you lawyers.
It broadens out. And so now anyone who has a health problem, which is half the people pretty much, could claim that it's causing them, problems on a day-to-day basis. And then, this cycle begins. So as far as small business owners go, I advise them to contact someone like me.
So I have 2 minutes left. Talk to me about people who are on prescription medication and feel that prescription medication is actually, and it affects their job performance. And I'm thinking more along the lines of like any pain or antipsychotics or things like that actually are mood altering or affect their concentration.
That is an excellent issue, and it's a complex issue. It can't really be handled in 2 minutes, but I can tell you there's case law on both sides. There are real arguments, salient arguments on both sides, so it becomes very fact-specific. In general, if you have an employee who is in a safety-driven position, driving, healthcare, you're not going to probably have to accommodate that. Most other employees, there are cases that would mandate that you accommodate that. The reason being that one of the big problems with narcotics is that people develop a tolerance.
Yes.
And so you can be on a high level of narcotics, but if you've been on that high level for a long time, your functioning is normal. So it's really
It's a case by
fact-specific.
case?
It's pretty case by case, except with regard to safety. I mean, probably dealing with high amounts of money too.
Well,
But-
yeah. Well, even DOT, you can't have uncontrolled diabetes. You can't have uncontrolled hypertension. Can't be on pain medication or anything like
Right.
that. And definitely with the new medical marijuana laws, you cannot be high.
Right.
People, you cannot be high at work.
Yeah. Well, that's a whole other issue. Sometime I could spend a whole show talking about medical
Maybe
marijuana.
you need to come back.
I will come back and talk about medical marijuana and drug testing. But my contact, I'm at mjlawvegas.com.
That's mjlawvegas.com. And if they want to call you,
They can call my cell phone, 702-287-0095. If you call me, I'll get back to you, and I will give you some advice that can save you thousands and thousands of dollars. I can usually
you're a
evaluate.
lawyer for the people.
I'm a lawyer for the small business owner, the middle business owner, and the people. I really am.
I love it. Thank you very much, Martina. Martina Jaccarino with mjlawvegas.com, or you can call her at
702-287-0095.
Thank you for coming in today.
Thanks for having me, Tina.